let's say you are the trustee of a trust. Do you own the property? That's not an easy answer. The easy answer is no, you don't own it. You're the trustee, so you don't own the property that is in the trust. So let me make it as simple as I can. Let's say that this is an irrevocable trust. Maybe this trust was created by your parents. Let's say your mom died and her will has a trust in it for your dad, or maybe a trust in the will for maybe your special needs sibling, and you're the trustee, but other people are beneficiaries of this irrevocable trust. So in that instance, it's pretty clear that you are not the owner in terms of the person who gets the benefits from the assets in the trust. Instead, that would be your father or your special needs sibling. So as a general rule, the trustee isn't the owner of the asset for purposes of getting benefits of the assets. They are fiduciary. They're managing the property for the benefit of some other person, even if the asset is titled in your name as trustee of a trust. So when it comes to being trustee of a trust, really have to look at what kind of trust is it? Is it irrevocable for the benefit of somebody else? Then you are in a fiduciary capacity, and as the trustee, you're responsible for making sure there's insurance on the asset, making sure property taxes are paid if real property is in the trust, making sure that the beneficiaries get the benefit of the assets in the trust, and all sorts of other rules that a trustee as a fiduciary must follow. For example, including filing any necessary tax returns. So you have the responsibilities of being the owner and maybe even the legal title, but you don't get the benefits of the assets. So being a trustee is a job. Now, what if the trust we're talking about that you're a trustee of is called a revocable living trust? And let's say you and your spouse, as your estate plan, have a revocable living trust, and you're alive, your spouse is alive, you and your spouse put all your assets into this trust, you retitled your bank account, you put your house by deed into the trust, which means into the name, your name and your spouse's name. So the house used to be in your name and your spouse's name. You put it into the trust in your name and your spouse's name, but as trustee of this trust, revocable living trust that you created. You're the beneficiary of the trust, so you get all the benefits of this asset that's in the trust. And because it's a revocable living trust, you don't need to file any different tax returns because this trust doesn't have a separate tax ID number. So in that way, since you used to own the property, you put it in the trust and you're the owner as trustee and you're the beneficiary, and you could end this trust at any time, you and your spouse, for example, then you really do feel like you're the owner of this the properties that are in this trust. So in that situation, you pretty much are the owner of the trust assets, because this trust you could revoke at any time if you wanted to. You don't do a separate tax return. There's no separate tax ID number. But if it is you and your spouse, then we get into more issues about who owns what within the trust. In Washington, we have community property. In other states, there isn't community property. So that complicates it even more. I will have to say that one of the reasons that revocable living trusts raise so many questions is that if you do have a revocable living trust like I just described, it doesn't feel any different. The only thing is that your attorney said you have to retitle the assets into the name of the trust, and then everything goes on as it was. You still get all the benefits. No other work is required. So when it comes to revocable living trusts, they're often looked at as being pretty simple estate planning tools and fixes to not doing a probate on death, but keep in mind that you need to understand your trust, how to administer it, and in particular, what happens when the first spouse dies. What are the responsibilities of that successor trustee, the surviving spouse? Because it may be to create an irrevocable trust, even if it's for the surviving spouse's benefit. And then it looks much more like an irrevocable trust with the person who is the trustee and is also the beneficiary being a fiduciary, not just for themselves, but for the remainder persons of that trust, that may be the kids. So trusts, whenever you hear the term trust or you hear the term trustee, I want you to just kind of stop and say, I need to know more. I need to ask more questions. And you can research it. You can do all of these things to educate yourself, and that's a good thing. But really, to get your questions answered on your particular situation, you need to see an attorney who either prepared the trust or understands trusts.